Take you to another important story tonight, and in a landmark judgment, the Constitutional Court has ruled that common purpose applies in rape cases. This means that a person can be found guilty of rape even if they did not commit the act but were part of a common plan that included the rape. The judgment comes after Jabulani Shabalala and Ananias Ntuli challenged their rape convictions under common purpose in a case from the late 1990s. Joining me now to talk more about this is lawyer and gender activist Letlhogonolo Mogorwane, I beg your pardon. Letlhogonolo, very good evening to you. Thank you so much for coming in. Let's go back to the background. I touched on it slightly, but we're talking about two men who were involved in a case that goes back all the way to 1998.
Yes.
Walk us through what's brought us here.
Okay, so in 1998, these people committed a crime which was basically going to homes in Tembisa and about committing crimes in about 9 or 8 countries, but 9 or 8 houses. And what happened in this instance was that they raped 8 female occupants. And then they were sentenced, found guilty, sentenced to convicted, and then sentenced. And there was another accused who, in a separate matter, appealed the decision, and that went to the Supreme Court of Appeal, and the Supreme Court of Appeal said common purpose does not apply. So these people were like, oh wait, this is someone who was in cahoots with us, so let's also appeal. And then they appealed to the Constitutional Court, basically saying, well, based on the judgment of the SCA, common purpose does not apply to rape cases, and therefore we should be acquitted.
So on common purpose, what it means is if you and I attack a person and then one of us rapes that individual, by being part of the plot or the planning, I'm also guilty of the crime, right? Am I following correctly?
Yes. So there are two types of it, right? On the one hand is that we have a prior arrangement.
Okay.
I always think about Sarafina. Do you remember the moment where the character who played Bongeni Ngema, the students wanted to kill and bomb his house? That is common purpose. There's a prior arrangement for them to come and effectively murder him, right?
But of course the trick with this in a court would be proving the prior arrangement. So that's where it gets difficult.
But there is some evidentiary rules. You can know, circumstantial evidence, witnesses that can say, like in this particular case, what happened, the court made some factual inference and said, well, we can see that these people had a particular pattern, and this particular pattern meant robbing houses, assaulting people, and then raping people, and it happened in the same time period. So we can say that they had a common purpose in that regard. The other element of common purpose, or the other way in which common purpose can be achieved, would be by active participation. So let's say we are going to rape someone and I hold someone down. Effectively, we are also participating actively in committing the crime of rape. Previously, the common law definition of rape was that you had to insert a male genitalia in a female genitalia. So based on that, they said common purpose could not apply.
And in terms of bearing on previous cases, would a judgment like this now have bearing on cases that are still before the courts, or could even people who've gone through similar situations now have their cases revisited? Is that a possibility legally?
Well, yes, it is. I mean, people could say that new evidence may have come, but what this judgment is prospective. So it will be applied for future cases and not necessarily for cases that have already been decided.
Sentencing implications? Would a person, because I mean, for the rest of us who aren't law scholars,
yes,
do you then sentence the two people in the same way, the one who committed the act of the penetration and the other now also a rape convict, even though he was either in the planning or in the room doing something else? So
the whole idea of common purpose is to impute, attach the guilt finding on someone else who may not have participated in the rape. So what happens is that it would be as if you and I both raped the person. So whatever sentence, according to the Minimum Sentencing Act, will be applied to rape victim will apply to both of us.
And I was quite struck because in the reading out of this judgment, the Constitutional Court took on quite a strong gender and feminist approach to just the scourge of attacks on women in this country, which is quite important in the context of the alarming rate of gender-based violence and how women, for example, rape has been used as a means of oppression for them. That's what essentially what the court was saying.
Yes, no, well, we have to be grateful for the Commission for Gender Equality as well as the Center for Applied Legal Studies. They were friends of the court, and they effectively were the ones who brought the feminist approach into the court, right? The first judgment, which was the main judgment, basically said, listen, it's important for us to, ensure that the scourge of gender-based violence does not increase. So we also have to participate as courts and know that we're saying no to this. The second judgment, I think, for me, written by Justice Khampepe, is more feminist, because Justice Khampepe is saying rapists are not monsters. They are people that we know. So in order for us to know that reality, that we live in a system, right, where this is possible, we're able to, effectively reduce gender-based violence, because we're not calling these people monsters. What we effectively are doing is saying they are just ordinary people, and we are part of the system.
Thank you so much for explaining that for those of us who are interested in such issues but may not have the legal understanding of the laws, but it'll be very interesting to see just how it is applied going forward. But again, thank you so much for being on Nightline tonight.
Thank you.
That was lawyer and gender activist Lekgono Mogorwane.